A seismic shift is underway in the American legal landscape, one that threatens to reconfigure the very architecture of dispute resolution and access to justice. This is not merely an incremental technological upgrade. It is a fundamental replatforming of the legal system, driven by the explosive growth of DIY e-litigation. The confluence of pervasive digitization and an enduring access to justice crisis has ushered in an era where millions of litigants are, by choice or necessity, navigating complex legal processes without legal counsel entirely through electronic means. Consider the staggering data. In California, one of the nation's largest legal markets, over 70% of civil cases in some jurisdictions involve at least one self-represented litigant, a figure that has steadily climbed over the past decade. Nationally, the Legal Services Corporation reported in 2022 that 74% of low-income households experienced at least one civil legal problem in the past year, yet a substantial majority received inadequate or no legal help. This unmet need, juxtaposed with the rapid deployment of e-filing systems across state and federal courts, with many jurisdictions mandating electronic submissions, creates a potent, often volatile, crucible for the phenomenon of DIY e-litigation. This is not a niche concern. It is a systemic challenge demanding immediate, rigorous analysis. The stakes are immense, impacting everything from the integrity of court records to the due process rights of individuals and the operational efficiency of judicial systems. As courts, from the Supreme Court down to local municipal tribunals, increasingly embrace digital workflows, the assumption that legal professionals are the exclusive gatekeepers of procedural knowledge is being aggressively challenged. The implementation of e-filing portals by companies like Tyler Technologies, whose Odyssey platform is ubiquitous in state courts, has democratized the act of filing documents, ostensibly reducing barriers to entry. Yet, beneath this veneer of accessibility lies a complex reality. While the act of filing may be simpler, the substance of effective litigation, drafting coherent pleadings, understanding evidentiary rules, adhering to procedural deadlines, and responding strategically to opposing counsel remains as daunting as ever. The question, therefore, is not whether DIY e-litigation exists, but rather, what are its precise contours, its unacknowledged costs, and its potential to either expand or contract genuine access to justice in the digital age. This article will dissect this critical juncture, offering a comprehensive framework for understanding the profound implications of the pro-SE digital frontier for legal practice, judicial administration, and the very concept of fairness in a digitized legal system. The burgeoning reality of DIY e-litigation is not a theoretical construct, but a quantifiable phenomenon, reshaping access to justice and the operational calculus of legal systems across jurisdictions. This landscape is characterized by a significant and growing cohort of pro-Southeast litigants leveraging digital court infrastructure, often driven by the prohibitive costs of legal representation and enhanced technological accessibility. For instance, the National Center for State Courts, NCSC, consistently reports that self-represented litigants comprise a substantial majority in civil cases, particularly in family law, housing, and small claims courts. In jurisdictions like Maricopa County, Arizona, over 70% of civil cases involve at least one self-represented litigant, a figure that largely predates but is now amplified by the proliferation of e-filing mandates. California's Judicial Council, in its 2022 annual report, highlighted that the state's e-filing portal processed over 100 million documents in the preceding year, a significant portion of which originated from individuals directly interacting with the system. While precise figures disaggregating self-represented filings from attorney filings via these portals remain challenging to obtain uniformly across all states, anecdotal and localized data strongly suggest a substantial and increasing reliance by self-represented parties on these digital pathways. Real companies are actively responding to and, in some cases, catalyzing this shift. LegalZoom, for example, has long offered document preparation services that, while not constituting the practice of law, empower individuals to draft filings for uncontested divorces, small business formations, and other common legal matters, effectively streamlining the entry point into the e-litigation system. TurboTax, by simplifying complex tax code into user-friendly interfaces, provides a compelling analog for what many pro-SE advocates envision for legal processes, suggesting a market for intuitive, guided self-service platforms for document preparation. More direct players are emerging in the legal tech space, such as Hello Divorce, which specifically targets the uncontested divorce market with guided online forms and e-filing assistance, illustrating a niche but rapidly expanding segment of the market focused on document automation and electronic submission. Even the federal judiciary has observed this trend. The Administrative Office of the U.S. Courts noted in its 2021 report on the federal judiciary that while attorneys overwhelmingly dominate federal court filings, the increase in pro-SE prisoner filings, often submitted electronically, underscores the universal impact of digital access. The COVID-19 pandemic further accelerated this digital pivot, with courts across the nation, from the New York State Unified Court System to the Texas judiciary, rapidly expanding their e-filing capabilities and virtual hearing platforms, making digital engagement less of an option and more of a default. This rapid forced adoption has, in turn, normalized the idea of direct digital interaction with the courts for a broader swathe of the populace, laying fertile ground for the continued expansion of DIY e-litigation. The operational architecture of DIY e-litigation is a complex interplay of public infrastructure, proprietary software, and user-centric interfaces, all designed to facilitate the self-represented litigant's engagement with the judicial system. At its core, the mechanism revolves around the electronic filing system, EFS, a digital portal that serves as the primary conduit for submitting legal documents to the courts. This system, often developed and maintained by third-party vendors such as Tyler Technologies, which powers many state court e-filing systems, including those in California, Texas, and Florida, is a sophisticated web application. A litigant initiates the process by accessing the court's designated EFS, typically through a web browser. This requires prior registration, a crucial gatekeeping step that authenticates the user and establishes their digital identity within the system. The registration often involves multi-factor authentication, reflecting the need for secure access to sensitive legal data. Once registered and logged in, the user encounters a dashboard that guides them through the various stages of a legal proceeding. For instance, a self-represented litigant might select a new case filing option. This triggers a series of prompts, requiring the user to identify the case type, e.g., small claims, family law, landlord-tenant disputes, designate the parties involved, and specify the court jurisdiction. The technical backbone of these systems relies on robust database management systems, often SQL-based, to store case information, litigant data, and document metadata. When a litigant uploads a document, say a complaint or a motion, the EFS typically converts it into a standardized format, most commonly PDF/A, PDF for archiving, to ensure long-term readability and integrity across different platforms. This conversion process is critical, as it ensures that documents are preserved in a format that is independent of the software used to create them, facilitating consistent access and review by court staff and other parties regardless of their operating systems or applications. The system then assigns a unique case number and date stamps the filing, which is crucial for establishing compliance with procedural deadlines. Beyond simple document submission, many EFS platforms offer additional functionalities tailored to self-represented litigants. These may include access to electronic service of process, where the system facilitates the digital delivery of documents to opposing parties, often requiring the opposing party's consent or a court order for electronic service. Some systems also provide access to case calendars, allowing litigants to track hearing dates, deadlines, and other critical events. Furthermore, document templates for common filings, e.g., motions for continuance, requests for orders, are increasingly available directly through court websites or integrated into the EFS, aiming to assist self-represented individuals in conforming to court rules regarding formatting and content. While these templates can guide litigants, they typically do not offer legal advice or strategic guidance, placing the onus on the individual to understand the substantive legal requirements and implications of their filings. The integration of these various functionalities within a single digital portal aims to create a streamlined, if not simplified, pathway for self-represented individuals to engage with the modern judicial system. The rise of DIY e-litigation presents a complex, often contradictory, impact on access to justice. On one hand, it undeniably lowers certain procedural barriers, theoretically expanding the reach of the courts. The ability to file documents from any internet-connected device at any time removes geographical and temporal constraints that disproportionately affect individuals in rural areas, those with limited transportation, or those unable to take time off work during court hours. This convenience can be a significant boon for individuals who previously found it physically impossible or prohibitively difficult to interact with the justice system. Furthermore, the reduced reliance on paper filings can decrease costs associated with printing, copying, and postage, which, while seemingly minor, can accumulate into substantial burdens for low-income litigants. The digital format also facilitates the creation and dissemination of self-help resources, allowing courts and legal aid organizations to provide online guides, FAQs, and interactive forms that can be accessed widely. However, the purported gains in accessibility are often offset by significant challenges, particularly concerning substantive justice. While e-filing simplifies the act of submission, it does not inherently simplify the substance of law. Self-represented litigants frequently struggle with legal complexities such as understanding jurisdiction, drafting legally sufficient pleadings, adhering to evidentiary rules, and conducting effective discovery. The absence of legal counsel means that individuals may inadvertently waive rights, miss critical deadlines, or fail to present their case in a procedurally compliant or persuasive manner. For example, a litigant may successfully e-file a complaint, but if that complaint fails to state a claim upon which relief can be granted, it will ultimately be dismissed, rendering the initial accessibility moot. Moreover, the digital divide remains a potent barrier. While internet access is widespread, reliable high-speed internet, access to appropriate hardware, computers, scanners, and digital literacy skills are not universally distributed. Individuals in underserved communities, the elderly, or those with disabilities may face significant hurdles in navigating complex e-filing portals. Even with access, the sheer volume of information and the technical nuances of court systems can be overwhelming. The NCSC's 2020 report on technology and the courts highlighted that while many courts offer public access terminals, the support staff available to assist self-represented litigants in using these systems is often limited, creating a gap between technological provision and practical usability. The impact on judicial efficiency is also mixed. While e-filing reduces physical paper handling, court staff often spend more time assisting self-represented litigants with procedural errors, incomplete filings, and general navigation of the system. This can paradoxically increase the workload for clerks and judges as they grapple with filings that do not conform to established legal standards. The potential for an increase in appeals or motions to vacate judgments due to procedural missteps by self-represented parties also looms, further straining judicial resources. Therefore, while DIY e-litigation undeniably expands the opportunity for individuals to engage with the legal system, it simultaneously highlights the persistent need for substantive legal guidance and support to ensure that this engagement translates into genuine access to justice and fair outcomes.